The appellant claimant felt aggrieved by the order of the High Court filed two appeals by way of special leave in this court staff. One is filed against an order by which the claimant's appeal for enhancement in the quantum of compensation was dismissed as having rendered infructuous, and the other is filed against an order by which the insurance company's appeal was partly allowed by reducing the quantum of compensation from rupees 24,62,065 to rupees 20 lakh staff para. It may be mentioned that so far as the insurance company is concerned, they have not filed any appeal against the order of the High Court staff. In other words, the insurance company seems satisfied with the quantum of compensation amount of rupees 20 lakh awarded by the High Court by the impugned order staff para. The third question, which arises for consideration in these two appeals, is whether the High Court was justified in allowing the insurance company's appeal within bracket MACA number 839/2014 bracket out and was, therefore, justified in reducing the quantum of compensation amount from rupees 24,62,065 to rupees 20 lakh and, in consequence, was justified in dismissing the claimant's appeal for enhancement of the quantum of compensation as having rendered infructuous staff para. Learned counsel for the appellant claimant, while assailing the legality and correctness of the impugned order, contended that the High Court, without adverting to any factual and legal issue arising in the case, simply allowed the insurance company's appeal and reduced the compensation from rupees 24,62,065 to rupees 20 lakh awarded by the tribunal and, in consequence, dismissed the appellant claimant's appeal in a cryptic manner staff para. According to learned counsel, the High Court neither set out the facts, nor dealt with any issue, nor appreciated the ocular and documentary evidence, much less in its proper perspective, nor examined the legal principles applicable to the issues arising in the case, and nor rendered its findings on any contentious issues decided by the tribunal, except to observe, quote, considering the submissions of the learned counsel for the parties, quote, and, quote, I feel, the interest of justice would be best served if the awarded compensation amount of rupees 24,62,065 is modified and reduced to rupees 20 lakh quote staff para. Learned counsel for the appellant submitted that it was not the consideration of the case of either parties at all, and yet the insurance company succeeded in their appeal and appellant claimant lost, which caused prejudice to him due to reduction in quantum of compensation staff para. Learned counsel further contended that it was the duty of the High Court, exercising its first appellate powers under section 173 of the MV Act, to have dealt with all the submissions urged by the parties, and after appreciating the entire evidence should have come to its own conclusion one way or the other, keeping in view the legal principles governing the issues as to whether any case was made out for enhancement or reduction in quantum of compensation, as the case may be stopped. It was urged that since it was not done by the High Court, a jurisdictional error is committed which renders the impugned order legally unsustainable. Stop.